Okay, before I get started, I am going to note that there are pending charges that we have not received from the prosecutor's office yet, so I won't be arraigning you on those. However, I will be arraigning you on 24FB1048. That is the State of Michigan versus Antoine Brown. Names for the record, please.
Ashley Moten on behalf of Mr. Brown. State your name, sir.
Antoine Brown. And what's all these other cases?
So I don't have more information yet. It sounds like there's a new pending case.
Okay, so what are we here? We're here for my probation violation?
Yes.
Okay, so then, okay, that's what this one for. So the new one's going to be for the alleged domestic.
Yes, and that will potentially be tomorrow. I don't have charging documents, so we'll see. In any case, what I have here is a probation violation report from Officer Johnson that alleges the following. One, that you were discharged from the Accountable Choices program on June 17th. And then also that you potentially obtained new criminal charges in the offense of domestic violence. I have a police report dated July 6th. So this police report involves the same victim, that being the person that you're not supposed to be having contact with.
Why does everybody keep saying I'm not supposed to have contact with somebody?
No unwanted contact.
Okay, yeah, so I had the wanted contact. That's my address. I don't know why people keep saying that. You know, unwanted contact is either contact or no contact.
Okay, Mr. Brown, we are on YouTube and the record, so I would.
I know we on my mom and them watching. I'm trying to make
statements.
sure that they understand what's going on. It's probably everything is show. YouTube. And what day did she say I got discharged from that class?
Yes.
What day did I get discharged from the class?
This states discharge from Accountable Choices program on June 17th.
On June 17th?
Yes.
I ain't been to that class in almost 2 months. And I went to go see I went to court on June 9th. So then why didn't it say nothing then? They didn't say come turn yourself in or anything, but now all of a sudden I'm up here and all of a sudden it's, oh, well, you're out of a class and you didn't take a class. And I haven't been in the class in almost 2 months. And Ms. Johnson knows that because she offered me to go to therapy. So I'm trying to figure out why would it be a violation, or that just don't make sense. It doesn't. That's the problem with this. I got all the paperwork at home from her saying everything from the therapist and all. I'm not supposed to be in that class. I don't even know why that class is even brought up. Just see Ms. Washington. Ms. Washington said, good job. Keep doing the good work on June 9th.
Okay, Mr. Brown. Let's wait one moment.
So at this time, the court will set a hearing for a violation of probation that will be on Monday, July 14th, 2025. That will be at 9 in the morning over Zoom in front of Judge Washington. At this time, bond is being denied.
Was I not able to make a bond argument?
I'm sorry. Yes, you can make a bond argument.
Okay, thank you. I did not have a violation report, so this is the first time I'm hearing any of this information. First, I want to confirm, is one of the violations being discharged from the program?
So what I'm seeing on this is it specifically states, I allege that the defendant has committed the following technical probation violation, discharge from the Accountable Choices Program on June 17th. And
Okay.
then the non-technical probation violations, the police report involving the same victim. Okay.
Okay. And I asked that because obviously he was not aware that he was discharged from the program. He hasn't received that information, although he has been in contact with his probation agent. It appears until this report, he has been compliant with his probation terms. It seems that he is being violated for new charges, although the charges have not been authorized. And I know a part of his terms is no unwanted contact, but it's my understanding that she was at his home when he was arrested. So in that case, obviously, if she's made the effort to go to his home, then she must have allowed some type of contact. He does have family support. He is gainfully employed. He is a father. I know that he has a GPS tether. I do believe that would be sufficient in order to keep any concerns that the court has for the safety of the community. And we're requesting consensual third-party contact for child care purposes and a personal bond. Thank you.
Thank you.
Cause I ain't been in no trouble since I've been on probation. I ain't did nothing. Everything has been going good. I ain't missed a court date or nothing. Shit, I'll take the tether. I'll take the tether back. Don't mind.
Okay. Thank you for your patience. So, couple of things. One, it looks like that last review date in front of Judge Washington was on June 9th.
Mhm.
The regarding the Accountable Choices Program, the allegation per the probation officer is that you stopped going to the Accountable Choices Program sometime in April.
Right.
So that's where that comes from.
Right.
And that information came in apparently after that June 9th court date.
No, she
Between that-
how would that make sense? Because my probation officer.
Okay. Just
Okay, I got
let
it.
me finish, please. Thank
Okay.
you.
I hate
So,
language, bro. I hate
between that and then as far as the terms of your probation go, it does specifically state that you're restrained from any sort of unwanted contact. And just based on the what I'm seeing in the police report, it indicates to the court unwanted contact. And as a person with conditions placed on you,
I was trying to.
okay. So at this point, you've got the violation of probation date that's July 14th for the
Can I
hearing in front of
ask you a
Judge
question?
Washington.
Can I ask a
Yes.
question? So does this make sense if I talk to my probation officer every month? My probation officer knew before June 9th that I wasn't in that class. She knew
I
that
don't
because
know
I
that
talked
she
to her
did.
every day. No, she does
Okay.
because I talked to Ms. Johnson. Ms. Johnson knows everything, and she told me to go to therapy. So she knows I'm out of the class. She been knew I was in the class because she told me to go to therapy and get the therapist. That's what we were changing it for. So why all of a sudden is she lying and saying
Okay,
she didn't know? And
Mr. Brown, and I understand that you want
That's
to,
not
you
cool,
should
bro.
talk to your public defender about this, okay? Because this is what can be discussed at the hearing in front of the judge. I cannot talk to you about this.
I'm saying
Okay.
'cause I'm in here and I haven't violated anything. I've done everything that they've asked me to do, paid money, gone to the classes. It's okay though. I get what y'all do. It's just what y'all do. Here we go. This is bullshit.
Mr. Brown, you are free to go to the door and tell the jail that you're finished. Thank
I know
you.
they know I'm done. They'll come when they come. I'll just stand up and sit around for y'all.
All right, let's talk about that. The hearing for Antoine Brown was one of those moments where courtroom formality meets personal frustration, and we saw both in full force. Mr. Brown appeared for an arraignment on an alleged probation violation, and right from the start, he seemed genuinely baffled by the entire situation. He didn't deny being in contact with the individual named in the police report, but he did push back, repeatedly, on whether that contact was unwanted. That became a recurring theme. His confusion was clear. Is it contact or no contact? He asked, raising a point that, frankly, isn't as rhetorical as it sounds. And when he found out one of the violations stemmed from being discharged from a program, he claims he hadn't attended in 2 months, while supposedly switching to therapy with his probation. Officers acknowledged his frustration hit a new level. There were no fireworks, but plenty of disbelief. Magistrate Hilary Braley handled it with a cool head, keeping the tone firm but controlled. She repeatedly asked Mr. Brown to hold his comments and let her finish. And to her credit, she kept things from veering into chaos. When defense attorney Ashley Potter jumped in, she did a good job clarifying that this was the first she'd heard of the violations herself. She argued that her client hadn't knowingly violated anything, especially if the contact in question was initiated by the other party, and if the class absence had already been discussed with his probation officer. She asked for a personal bond, highlighted that Mr. Brown has a job, kids, family support, and even offered to reinstate a GPS tether to ensure compliance. Brown echoed that sentiment himself. I'll take the tether back. Don't mind. But, in the end, bond was denied, and the matter was set for a probation violation hearing. That wasn't what Brown wanted to hear, and he let the court know. There was no yelling, but there was a simmering undercurrent of being wronged. His final words, before heading back, summed it up in classic defendant frustration. It's just what y'all do. And while it's easy to write that off, it does reflect how opaque this process can feel to the people inside it. The whole interaction was a study in competing realities. On one side, a court doing what it does, relying on reports, setting hearings, keeping to schedule. On the other, a man who feels like he played by the rules and is still getting penalized. It's not about who's right or wrong, it's about how delicate the balance is between compliance and communication, especially when systems move faster than people. And it's a reminder that technical violations don't always feel technical to the people experiencing them. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.